anything and everything that is acquired during marriage, barring a prenup being in place, is going to be considered community property. And on this petition, we are not deep enough into the process a lot of times to list out in full. So we'll simply put, and it's okay to put, all property acquired after date of marriage and before date of separation. What is going on, guys? My name is Mark Reel Jr., the Father's Rights Attorney, and you are watching lesson number 3 on our masterclass on divorce in the state of California. So in the first 2 lessons, we went over the 30,000 foot view of what to expect, the timelines, and some major issues. In today's lesson, what we're going to break down is the initial petition and the response to that petition. So really how your divorce is going to get started. So this is going to be step 1 in every single divorce. So in the state of California, we have in family law a form-based practice, which means that in theory, you can get divorced, child custody can be decided, everything by just filling out forms. Now that isn't always the case. There's some benefits to not using forms in certain situations. There's some stylings and some document prep that as a firm or as a lawyer we have that we can use. In order to get your case started, you're going to need to file an FL100. And I'm going to go over here to this side of the board. And we have the petition. The first document you are going to need to fill out, the first judicial counsel form, is the FL100. And I have the FL100 right here on the screen. And these documents, at first blush, are going to feel very complicated. There is a lot of words. There are a lot of words on this document, and it can feel very complex. Now, the key to any of these judicial counsel forms is going to be just working your way down through the numbers. So we can see we've kind of cropped the heading out so we can have a lot more of the substantive information on here. And we can see first thing we do is we go down to number 1, legal relationship. So you're going to be able to list out what your legal relationship is. Now 99% of the time when it comes to legal relationship, you're going to be we are married. The other options B and C are domestic partnership established in California and domestic partnership not established in California. But the vast majority of the time, we're checking the A box. Number 2, residency requirements. Now, even a divorce without kids, there's going to be certain residency requirements that must be met in order for California to have what we call jurisdiction over your divorce. Now, the standard is that you must have lived in the state of California for 6 months and in the county you are filing in for 3 months. So for most people, this is pretty straightforward. When we talk about military or some other situations, recent moves, it can get a little bit more complex. But in general, you're going to have lived in the county you file in for 3 months. Now, moving on to number 3 here, this on the petition and response are probably the most important pieces of information you are going to fill out in these initial documents. Statistical facts. So, date of marriage and date of separation. So, your date of marriage and your date of separation are major factors when it comes to division of community property and potentially spousal support. So, California being a community property state, any assets acquired after marriage or before separation are considered community property. Getting these numbers wrong could cause issues with the division of property or could cost you a significant amount of money when it comes to spousal support. So that's a piece that we really want to focus on. And the date of separation, that's usually the most challenging one. Date of marriage, we have a marriage certificate. The date of separation is a little bit more of a gray area. It can be when one party moved out of the house. It can be when one party moved out of the bedroom. But these separations can also be disrupted and the date pushed further back by going on trips together, moving back into the bedroom, certain types of relations. So this is something that can be very, very important and can have a huge financial impact on your divorce and your life moving on. Number 4, we move on to the children. We're simply listing the name, birthday, and age. As we move on to page 2, the legal grounds for divorce. Now, in the state of California, we are a no-fault state. It doesn't matter if you cheated, it doesn't matter if she cheated, it doesn't matter if a crime was committed. None of that matters. We are a no-fault state. So there are only a few grounds for getting a divorce. Well, there are really only 2 specifically. Number 1 is going to be irreconcilable differences. The vast majority of divorces are for irreconcilable differences. Number 2 would be mental incapacity, say Alzheimer's, an injury, something of that nature, renders them unable to make decisions for themselves. There could be that second way. The other things listed on here to nullify or void: incest, bigamy, petitioner's age, prior existing marriage or domestic partnership. So the vast majority of the time we're going to have divorce, and we're going to have number 1, A1, irreconcilable differences. We move on. 6, we have one of our 4 key components of a divorce. We have child custody and visitation. We have legal custody, physical custody, visitation, and then there are some judicial counsel forms where we can get more specific on what we want. Now, these forms aren't required. They really aren't necessary in most cases, and typically we don't use them on the initial petition. We are more likely to use them in an RFO, which we'll discuss in a later lesson. All right, so moving on to number 7 here, we have child support. This is less about checking boxes or filling out information, more about really your rights in terms of child support. And then last, we have the spousal and domestic partnership support. So we can ask for spousal or partner support, we can ask to terminate it, or we can ask for it to be reserved for the future. And then we move on to page 3 here, community property and quasi-community property. Like I said earlier, with this date of marriage and date of separation, community property is going to be all property acquired after the date of marriage and before the date of separation. So anything during the marriage is considered community property. That can be wages earned, property purchased, toys, anything and everything that is acquired during marriage, barring a prenup being in place, is going to be considered community property. And on this petition, we are not deep enough into the process a lot of times to list out in full. So we'll simply put, and it's okay to put, all property acquired after date of marriage and before date of separation, because there may be some gray area, and the court may even have to go in and determine when the marriage started or when it ended. Other requests, the most common other request box here is attorney fees. There are 2 or 3 ways under the California Family Code which attorney fees can be obtained by one party or the other, and we have our signature. So ultimately, we walk through those 11 sections, those 11 questions, and we check the boxes, and that's going to give us the start of our petition. Now, with a petition, or with opening up this divorce action, you're going to have 2 other forms. The FL110, which is going to be your summons. This is going to give a little bit of information, and it's also going to list off what we refer to as the ATROS in the state of California, the Automatic Temporary Restraining Order. And then if you have a child, you're going to have to fill out the FL105, which is the Uniform Child Custody and Jurisdiction and Enforcement Act, which is basically you have to tell the courts why the state of California, why the county, and why this specific courthouse have jurisdiction and venue to hear your matter. Each county, so LA County, San Bernardino County, Riverside County, all counties will usually have a local form as well that you will have to go in. Riverside County, where I'm standing right now, the FL036 is the statement of venue, so you're going to tell the courts why, or you're going to declare why that specific courthouse should have jurisdiction over your case. So that is the petition. That is filing for a divorce if there's nothing in your case. Now we're going to flip to part 2, where I'll talk about the response. All right, and so now we're on to part 2 of what will be stage 1 of a divorce. So we walk through the petition and the other judicial counsel forms that are necessary to start a divorce. Now, let's talk about where over 70% of men start, and that's as the respondent. So what does this mean? This means that your soon-to-be ex-wife has filled out the FL100, the FL110. If you have kids, the FL105, has filed it with the courts and has served you with it. So someone over the age of 18 has handed you these documents and your divorce process has started. As the respondent, where most men are, your process is going to start with you getting served. From the time of service until you're required to respond is 30 days. This is very important because if you don't respond within that 30-day window, you potentially could be defaulted, and if you default, you could potentially lose some of your rights in the divorce. So what do we need to respond with? Well, it's a little bit easier to respond than it is to file the petition. So we're going to do 2 documents. First one here is going to be the FL120. So the FL120 is, and you can see here on there, the response to the petition. So it's going to ask for the same information that FL120 asks for. It's going to ask you for information about your relationship with the other party. It's going to ask about your residence. It's going to ask about children. It's going to ask about statistical data such as the date of marriage and date of separation, all the way down to custody, support, and any other orders that may be requested. So this form, and it's 3 pages just like the other, but we can see here we have 1, 2, 3, 4 on the first page, working through grounds for divorce, custody support. Looks almost identical. We get to the last page asking about community property and the requests. The only other thing you need to fill out outside of this FL120, if you're the responding party, is the FL105, that Uniform Child Custody and Jurisdiction and Enforcement Act document if you have children. So to respond, you're only going to need the FL120 and the FL105 if you have children. So all you need to do, if you're confused, you're still looking for an attorney, you don't know what to do, you're reeling from this, in that 30 days is to fill out the FL120 and the FL105, file it with the court, and serve it on the party that served you. So that's really stage 1. That's everything that goes into starting a divorce and responding and being able to move on to the next stages of the divorce. So we'll cover the next steps, the financial disclosures, in the next lesson. Thanks, everybody.